Dear participants, good afternoon. My name is Olena Perepelinska, and in my capacity of Vice President of ICC Ukraine and of a court member of the ICC International Court of Arbitration, I am delighted to welcome you at this ICC Centenary event on rebuilding projects in Ukraine, on applicable rules and dispute resolution. This year, ICC Court celebrates 100 years, and this event is a part of this worldwide celebration. The choice of a topic was also quite easy. Instead of general arbitration topics, we decided to concentrate on what is really important for Ukraine now. Rebuilding of Ukraine is widely discussed in various fora since last year. However, quite often the discussion has rather economic, investment, or regulatory angle. Instead, today, we will talk about very practical issues, which could arise in any potential or current rebuilding project in Ukraine, applicable rules and dispute resolution. As we will discuss today, both topics are of paramount importance for any potential investor or sponsor before they make final decision to invest into rebuilding projects in Ukraine. And better understanding of all these issues by all stakeholders of these projects might significantly facilitate all the stages of such projects, starting from negotiation up to their final implementation in Ukraine. And we will start this discussion with a keynote speech by Alexander Fesset, Secretary General of the ICC International Court of Arbitration and Director of ICC Dispute Resolution Services. He manages the work of ICC Dispute Resolution Service Department, including the Court Secretariat in Paris, New York, São Paulo, Singapore, Abu Dhabi Global Market, and Hong Kong. He read law at the University of Athens, Greece, having specialized in international commercial transaction and conflict law. Prior to joining the ICC Court, he practiced as counsel out of Athens, where he established a sole practice in 2008. He was previously an associate at an Athens-based law firm. Alex is a Cyprus national, admitted to Athens Bar, and speaks English, French, and Greek. Alex, the floor is yours, and we are very delighted to have you here online in Ukraine. Please.
Thank you very much, Olena, and a very warm welcome on my side and on the behalf of the ICC, the International Court of Arbitration, more specifically, to all of you who are participating from within Ukraine and from afar at this very topical conference. And as you first mentioned, Olena, the timing of this conference is quite significant, I think, primarily for Ukraine on the one hand, but also for ICC, also on the other hand. So let me take them in the reverse order. First of all, and again, you mentioned it first, this conference finds us at the very end of a very significant year for the ICC International Court of Arbitration, given that 2023 has been the ICC Court's centenary year. The court was established on the 19th of January, 1923, in Paris, under circumstances that, in many respects, are vastly different from the ones the world is living today, but sadly also in many other respects, all too similar to the situation that the world was living right before the early 1920s. And I'm referring, of course, to the First World War and its very bloody and catastrophic consequences. But as I said, we're also in a very timely setting for Ukraine itself. On the 14th of December, the European Union Council decided to open accession talks with Ukraine. And this is, again, something that we are monitoring on our side with a great deal of interest. And even before that, I believe it was in the spring of this year, the European Union expressed its wide support in providing, in being a protagonist in a global effort for financial support that is required to rebuild Ukraine once the war is over. And in that regard, of course, I'm referring more specifically to the announcement in early summer 2023 to the establishment of the Ukraine facility and its three pillars, amongst which, of course, the first one is broad support to Ukraine, including investments to support the economy, the recovery and the reconstruction and modernization of the country, the investment framework with support from the Ukrainian private sector, and of course, the assistance programs that are required under a third pillar, from primarily technical assistance and capacity building to local authorities, in order to ensure that that effort of investment to rebuild the country will actually nurture local talent and indeed be able to provide long-lasting beneficial results for the country, its economy, and its people. Now, why is the ICC interested in this? Well, again, let me just refer very briefly to the very essential philosophy that led to the establishment of the ICC International Court of Arbitration over a century ago, and the settings, again, that led to the creation of the ICC Court. Europe, in the early 1920s, was emerging from a very bloody and catastrophic First World War. And the founders of ICC, who are now known as the Merchants of Peace, business people from around the world, gathered in Paris and united under a very simple concept. In order to avoid war, we need global trade. Because if we have cross-border trade, then obviously commerce will flourish. If commerce flourishes, then that would lead growth to the local and regional economies. If there is growth in the economies, then a little bit further down the line, there will be prosperity to the countries engaging in international trade. And if there is prosperity, then ultimately there will be peace. And if there is peace, we will avoid the atrocities of war. And very closely connected to that very basic, as I said, observation, comes the need to ensure a dispute resolution process that will allow business to go back to doing business, and therefore not finding themselves tangled in long legal domestic processes, but actually being in a position to have, I think, a very basic mission accomplished. And that is the mission upon which the ICC International Court of Arbitration still abides by this day and will continue to abide by in decades to come. And that is that we need access to justice and the rule of law. This simple observation, if you like, is so fundamental to the establishment and the endurance of the ICC International Court of Arbitration that we decided very late in 2022 to set it out as our first and most important pledge included in the ICC Declaration on the next century of dispute prevention and resolution. You will find that document online and through the ICC app, and it is a simple two-page document that sets out our expectations with regard to what the future of disputes might look like. And again, may I emphasize the importance of this first pledge on ensuring access to justice and the rule of law. But why is private dispute resolution and prevention, such as ICC arbitration, mediation, and more tellingly, when we come to infrastructure disputes, dispute boards and expert determination, of such a paramount importance? Well, the reason is not because lawyers like disputes or because we want to ensure that parties enjoy arbitration or dispute boards or expert determination. Far from it. We just know that including a reliable dispute prevention and resolution clause in contracts mitigates the risk that might arise out of a contractual arrangement. And if ever there is a need to escalate or de-escalate a dispute, then the appropriate tools will be made available to corporates and state-owned entities in order to do again what it is that they need to do. Of course, the ICC setting is one that applies across the world, and even in times of crisis, such as the ones that sadly the Ukrainian people are experiencing today, we see that being fulfilled to the maximum. And that is where the second pledge under our declaration comes in, which is to ensure and hold fast to our very founding belief that we need an independent and neutral system to prevent and resolve disputes that is free from political influence and political dynamics. And that only by ensuring that condition may we actually proceed with having sound business and investment, and of course, ensure that all stakeholders identify this process as a legitimate one. I could go on, of course, dear colleagues, and list many more of the pledges that are included in the declaration, but I would like to focus perhaps on something slightly different. And that is, I think, quite significant when we contemplate what the two panels in today's event will be talking about, which is rebuilding. You will know probably by now that ICC arbitration is more closely associated with two leading industries among many, although there are quite a few more. And historically, ICC arbitration has been used consistently around the world in two specific industries. On the one hand, construction and engineering, and therefore infrastructure matters, and on the other, in matters concerning energy. And more specifically, I would say, in this day and age, energy disruption and energy transition, of course. So much, in fact, that over the past, if we just look at the past just a few years, we know that we have had a good 40% of our cases annually, or nearly 40% of our cases, arising out of infrastructure projects or energy-related projects. And that number has actually not been reduced, despite the global crisis of the past 4 years, or indeed the more closer to home crisis that Ukraine is facing today. What we also know is that ICC arbitrations concern disputes that arise out of contracts that mostly are concluded within over 5, 6 to 10, and sometimes even more years, which is, I think, a testament to the fact that ICC arbitration is seen, again, as a risk mitigating factor in long-term contractual arrangements. That doesn't mean that, of course, there is no room for contracts that might be concluded more recently, and we do indeed have a good number of those cases as well. But more than 37% of those cases arise out of contracts that are between 3 and 5 years ago, and more than 33% more than 6 to 10 years ago. Again, if one considers how many of the contractual arrangements arising in the context of infrastructure and energy matters tend to be long-term and interconnected contractual arrangements, then indeed one can see again the benefit of ICC arbitration in that regard. The complexity of matters, and indeed sometimes even the sizes of claims, are such that again speak towards a very important experience that the ICC court has in ensuring that parties can get the best avenue of redress when they are facing disputes in these two specific industries. I should say, however, again, as I did earlier, that this is not the only line of activity that we're engaged in, and that both arbitration and ADR matters also arise in the context of other forms of economic activity, including, and I think this is quite important, matters of finance, insurance and reinsurance, and tech and specialized technologies, which again, if one considers in the context of a rebuilding exercise, will probably be of equal importance to the others that I have just mentioned. Now, obviously, I would be remiss if I would not mention, as this is the last actual event that I am participating before the end of the year. And I'm very happy to say that, and I'm very pleased to be that this is actually the one organized by ICC Ukraine on such an important topic. If I did not mention, albeit a little bit briefly, some of the key achievements for ICC dispute resolution services and indeed the ICC court over the past 12 months. I have already mentioned the centenary of the court, which we did not want it to be perceived just as a cause for celebration, but primarily as a milestone that will allow us to catapult forward our founding mission and our key objectives. And indeed, this is work that has begun already this year and will bear fruit in the next 3 to 5 years. And I would ask you to watch the space closely. It was quite telling that in the end of August, we registered our 28,000th case. We have long left that behind. We're now close to 28,300 plus cases. And tellingly, that case filing concerned an infrastructure dispute, not involving Ukrainian parties, but again, I think it was a rather symbolic significance. The fact that again we had such an important milestone on the centenary year in a construction matter. During our centenary program throughout the year, there was a lot of activity, not just on case management and dispute resolution, but also in thought leadership and capacity building. And again, may I remind you of that third pillar of the EU reconstruction initiative that actually speaks towards assistance on the ground in order to ensure that whatever investments will be made will be durable. And the ICC Court has long worked towards building a global community and in ensuring that local talent can be nurtured in whichever jurisdiction and country ICC is active. And it is with that spirit that we actually implemented a new series of capacity building exercises, including the relaunch of the ICC Advanced Arbitration Academies, including an academy for Central and Eastern Europe that was launched late this spring, that actually paves the way for the next generation of arbitrator practitioners. There were other thought leadership initiatives that also were released or concluded throughout the year. And I just want to mention one, which I think, again, is of extreme relevance when one considers the topic of the conference of today. And that is the release in the summer this year of two products by the ICC Commission on Arbitration and ADR, a report and a guide, a report on facilitating settlement in international arbitration, and a guide on effective conflict management. Why do I say that these are so relevant in the topics to be discussed today? Both of them are aimed to increase awareness of the different alternative dispute resolution techniques that are available to those who want to use the ICC toolbox, and also to increase awareness on how settlement of disputes may be facilitated in the context of an international arbitration. And I would like to finish by mentioning, of course, that there is, beyond ICC itself, and in the context of building a global community with a local engagement across different fields, ICC has also been extremely active and faithful, I think, in the forging of partnerships. And it is with that in mind that I'm extremely happy to see colleagues from FIDIC attending the conference today, giving the long-lasting collaboration between FIDIC and ICC and the promotion of good standards and healthy practices when it comes to, on the one hand, the management of infrastructure contracts, and on the other one, on the avoidance and the resolution of disputes that arise thereon. I would like, therefore, to end with that before passing this back to you, Elena, and our esteemed colleagues who will be speaking during the next two panels, with my very warm thanks for having invited me today to speak on behalf of the court and ICC, and also for allowing me to express my very sincere sentiments on behalf of the whole ICC that 2024 will bring better news and a better outcome for everyone in Ukraine and around the world. Thank you all very, very much.
Alex, thank you very much for your inspiring presentation. So like a lot of information, and we invite our audience to consult the website of ICC where they can have all detailed information. We are also wishing you happy festive season, and we are always happy to see you at the ICC Ukraine. Thank you very much.
Thank you very much, Anna, and hopefully next time in Kiev.
Hopefully. Now we are turning to our first panel. I invite our speakers to join. My name is Anna Gyar-Sashko. I'm a Vice President of ICC Ukraine, and I will be a moderator of the first panel entitled "Could FIDIC rules apply to the rebuilding projects in Ukraine?" So before introducing our speakers, I would like to mention that our audience can ask questions on YouTube. There is a commentary section, so you can ask your questions there, and then we will have time at the end of our panel to address them. So we are lucky to have a stellar lineup of speakers today with us, very experienced. And our first speaker is Daduna Kokridze. Daduna is a general counsel at FIDIC, managing FIDIC contract and legal services. She advises on the delivery of corporate governance for the organization, its global operations. Daduna's role includes the protection of FIDIC's IP and strategic advice and contribution to drafting development of FIDIC's contracts. Her topic today will be general topic of using FIDIC contracts for rebuilding Ukraine. Our next speaker is Dr. Alexei Felyev. Alexei is a managing partner at the international law firm Integrities. Alexei is a recognized legal practitioner with 20-year experience in consulting mainly foreign business in Ukraine. Alexei specializes in large-scale projects in energy, renewables, real estate, construction, and infrastructure, involving foreign investment and related project financing. Alexei's expertise was recognized by the leading rankings such as Legal 500, Who is Who Legal, Best Lawyers. Alexei's topic today is general view of FIDIC contracts in Ukraine, experience in both public and private sectors, and general navigating the legal landscape of construction contracts in Ukraine when using FIDIC forms. Our next speaker is Aisha Nadar. Aisha is a senior consultant at Advocat firm in Stockholm. She is inactive in large-scale cross-border infrastructure and defense programs. For over 30 years, she has handled all phases of negotiation and implementation. She also advises clients on strategic procurement planning, contract drafting, contract management, and dispute resolution. She acts as arbitrator, mediator, adjudicator, and dispute board member, and has experience as the president and member of tribunal under ICC, ACC, DIAC, AAA, and UNCITRAL rules. Her topic today is the different aspects of successful operation contract management. Without further ado, I pass the floor to Daduna.
Thank you very much, Anna, for your kind introduction, and thank you to ICC and ICC Ukraine for inviting and for organizing this very important event, as Alex has mentioned, in a very critical time, and the time cannot be better to discuss rebuilding of Ukraine, and we do really hope that we will start rebuilding the Ukraine sooner rather than later. I would like to start by giving a brief introduction about the FIDIC and how FIDIC contracts can be used for rebuilding the projects. I will share the presentation on screen. I would like to as well firstly congratulate ICC for its 100 years centenary. I'd like to also mention that this year is very special as well for FIDIC, as it is celebrating its 110 years of anniversary. To give you a brief introduction, FIDIC is an international federation of consulting engineers, and it unites around 100 members from across the world. FIDIC objectives are to represent the consulting engineering industry globally, to enhance the image of the engineers, to be the authority on issues related to business practice, to advocate for viability of the consulting engineering industry, drive excellence in quality, risk and project management and leadership, to combat and condemn bribery and corruption and to promote ethics, integrity, and transparency in the industry. It promotes safe, sustainable, and resilient development, which is crucial for the infrastructure, and promotes diversity, equal opportunity, and inclusiveness. Also stimulates development of talent, and something that Alex has as well mentioned, the importance of it in its keynote presentation. These are the objectives enriched in FIDIC's statutes and bylaws, and everything FIDIC does is driven by those objectives. So as part of its objectives, FIDIC also published the standard form contracts and agreements for construction and engineering sectors. It provides the business practice documents, the guides, the guidance memorandums, rules, and the guidelines. The first FIDIC contract was published more than 65 years ago in 1957, and the fundamental principle was to provide a clear and logical sequence of clauses to remove any ambiguities in the implementation of projects, to eliminate as far as possible any speculative elements, and to provide fair distribution of risks that are, as we know, hugely inherent in the works of civil engineering and construction. Those fundamental principles continue to apply today, and the FIDIC contracts are drafted by engineers for engineers. It has a fair and balanced risk-reward allocation where the role of the engineer is critical. FIDIC has the main construction contracts referred as the FIDIC suite of contracts, and many of you have probably heard them by their nicknames of Red Book, Yellow Book, or Silver Book, and they provide for, the Red Book is for the works of construction, the Yellow Book is for plant and design build, and the Silver Book is for EPC turnkey projects. Along with the suite of contracts, FIDIC has also published the short form of contract, which can be used when the perceived level of risk is low and where the parties wish to use a simpler form, which does not require significant contract administration. In terms of the use of the 2017 suite of contracts, all three contracts have 21 clauses and similar structure and terminology. They provide step-by-step project management procedural mechanisms. They set out what is required, when is it expected, and whom by it is expected. So it provides a great tool for the project management. And the dispute avoidance is its key feature, followed by an arbitration as a final dispute resolution mechanism. As a default, FIDIC contract provides for ICC, International Court of Arbitration, as a dispute resolution mechanism, and this is one of the areas where FIDIC and ICC cooperation stands very strong for many, many years. Along the works contracts, FIDIC also has other variety of contracts. FIDIC published the client and consultancy agreements, which can be used for feasibility studies, for procuring the engineers, for procuring the consultants. It also has the contracts which are the sector specific. For example, when largely the works are of underground, then the FIDIC would recommend using the Emerald Book. FIDIC also has the JV agreements for the consultants, the subcontractor agreements, and as you can see in a contract, the worked example, those all fit together to procure the successful projects. For example, the construction contract would be used between the employer and the contractor to engage the contractor in delivery of the works, while the white book, as referred the client-consultant agreement, can be used for securing the consultant services or the engineer, and then the subcontract to subcontract some of the works to the other contractors. FIDIC also published the guidance documents, which provides the detailed clause-by-clause commentary on each FIDIC contract to which it refers to, and it provides interpretation of those contracts for the users. Now, the use of the FIDIC contract is easy because it's split in structure in two parts. The general conditions, which provides the main rules and risk allocation between the parties, and which FIDIC recommends that are not heavily amended or are not amended in the main document. And FIDIC, and the second part is a particular conditions, which provides with the ability to append the project relevant information or to tailor tailor the contract to the specific legal requirements. Accordingly, FIDIC contracts are applicable in various jurisdictions and as such can be easily adapted and successfully used on Ukrainian projects. And we will hear more from Alexei about the use of the FIDIC in Ukraine. A new feature as well, which is in the Green Book, is that FIDIC has provided the forms of communication as part of its publication, which provides a great tool to help the parties in the communication, in giving the notices or issuing the certification, which is readily as a template provided to the parties. FIDIC has also published the golden principles when it comes to the drafting of contracts. It has 5 golden principles to recommend to maintain the balance of the contract and for the contract to be regarded as the genuine FIDIC documents. It requires or recommends that the particular conditions are drafted clearly and unambiguously, that the risk allocation is not heavily amended, that the timelines are reasonable in the contract, and unless there is a conflict with the governing law, that the parties maintain the dispute avoidance and adjudication board in the contracts. So now a question: why has FIDIC become so widely used, and why are there benefits in using it? Why could they be applicable to be used in Ukraine for rebuilding the project? And I think the same answer to that is simple in the number of areas which I will mention now. Well, mainly, there are many standards for contracts across the world, but what FIDIC contract has unique is that they are international standard forms. So they are very, very widely used across the world in many countries, which provides a familiarity to their use and makes users comfortable to their application. It's suitable for common law and also for civil law jurisdictions. As I have mentioned, the particular conditions allow to tailor the contract to specific project requirements and to adapt to any legal requirements as may be laid down in the governing law of the contract or in the law of the Ukraine. They can be and are widely used on public and also on private projects, whether funded by the international financial institutions or whether they are funded by budget from the budget or by private funding. They reduce the costs of negotiation. Considering that the users are familiar with the project, the cost for negotiation is lower, and it also allows the tenderers to understand the risk, to price the risk, and to provide to risk the pricing easily as compared to, if say, a bespoke contract where the detailed study and analysis of the contract would be required in order to understand what pricing should be given for undertaking a specific risk. The extensive training is available on FIDIC contracts across the world by FIDIC Academy and by FIDIC certified trainers. As FIDIC provides guides and guidance documents, it supports the use of interpretation interpretation across the world, and it has a multi-tier dispute resolution mechanism, which is very important for the users and for the project participants in order for them to have a neutral venue for dispute resolution, and they are not bound by national say courts and courts. FIDIC constantly updates its documentation, which is, for example, last year in 2022, FIDIC has published the 2022 reprints of its 2017 editions. And this means that FIDIC is constantly receiving feedback from the industry, reflecting on the feedback and continuously improving the documents to make them tailor to the project requirements. It's used in more than 170 countries and in more than 28 languages, and they are endorsed by 8 multilateral development banks. In the slide here, you will see that the list of the multilateral development banks that have been endorsed FIDIC conditions of contracts to be used in a standard procurement documents, either as recommendations or as requirements, and those include World Bank, Caribbean Development Bank, EBRD, Islamic Development Bank, Asian Development Bank, and so on and so forth. FDIC contracts are translated in different languages with the support of FDIC member associations or the multilateral development banks as well. And on the slide, you can see that FDIC conditions of contract are also translated in Ukrainian language and can be readily made available for the use of the rebuilding of Ukraine. Those include translations on the main works contracts and also on the guide. FDIC publishes the guidance documents in order to help the users to navigate also through different times. For example, when the COVID-19 emerged and there was a need to provide support to the users how to navigate through the COVID pandemic, FDIC issued the guidance memorandum where it explains the use of specific clauses with different scenarios. And likewise, FDIC has issued the guidance memorandum on the effects of inflation and unavailability of the goods and labors following the pandemic, and also the impacts of the war in Ukraine. And this document is also available for the users. FDIC has put in place the Dispute Avoidance and Adjudication Forum to raise the awareness and importance of the dispute avoidance for successful delivery of the project, and has a number of other documents in a pipeline which are currently developed. And I will not go through the entire list, but which is key and important to mention in today's time is as well the development of the net zero clauses to provide sustainability for the full life cycle of the project, which should become available for sustainable development of any projects. FDIC contracts are supported by a pool of experts, and FDIC has the FDIC Academy, which provides the training on the use to raise the awareness of the knowledge, and also the certification of the individuals, which is quite important on international and on national levels, to have the specialist, knowledgeable, certified individuals in order to be able to deliver the successful projects. And FDIC supports the spread of the certifications in different areas, and as such has 5 certifications currently with adjudicators, trainers, contract managers, consulting engineers, and consulting professionals. With that, I think I will stop with my presentation. I will hand back to Anna, and for any questions, I'll be happy to answer after with the audience. Thank you.
Thank you very much, Daduna. A lot of information, a lot of insights, and I think also that our audience can consult the website. And if you have any questions, for now we don't, but please feel free to ask questions. And now we are turning to our next speaker with a perspective, with a Ukrainian perspective on using FDIC rules. Alexei, the floor is yours.
Thank you, Anna. Thank you also, Daduna, for the introduction, which helps a lot now to continue with my presentation, which is more about how to use or what is the experience in using the FDIC contracts in Ukraine. So the FDIC contract has been mostly used in Ukraine in the public sector and in the public infrastructure projects, and especially this is the Red Book, which has been mentioned by Daduna. This is where you actually have the employer providing the design and then the contractor taking over the execution. This practice of using FDIC has been mainly driven by the IFIs. This is another slide shown by Daduna, where you see that actually most of the international banking institutions have adopted the FDIC standards as the standards to be used. And for this reason, if there are projects financed by these institutions, this is very typical that they expect to have the FDIC form to be used. The legislative framework for especially IFIs and also some DFIs with Ukraine, which is mainly the international contracts, it has been fitted to use the FIDIC rules, especially if these projects are internationally financed. And probably the most relevant stakeholder we had using this type of contracts was Outdoor. This was the state agency responsible for infrastructure construction, especially roads and bridges. Just maybe to give an example, in 2021, Ukraine procured around $7 billion on infrastructure construction. And a major portion of this has been internationally financed, and a major portion of this has been done based on the FIDIC regulations. So the public sector has been definitely the driver for use of the FIDIC contracts. In the private sector, we have seen application of FIDIC standards primarily when we have foreign investors. When we have foreign investors, or where we have also foreign construction companies, they would typically use the FIDIC standards too, whereby Ukrainian stakeholders are rather unfamiliar with the FIDIC contracts. Over the last decade, so especially after 2014, I would say that the biggest Ukrainian contractors are now familiar because of the use of the FIDIC within the infrastructure project. They are mostly now familiar with the FIDIC, and now this is I would say an animal which would not make the eyes big if you mention, but still in many sectors and in many respects, this would be a new form to be used. And yeah, as already mentioned, the Red Book probably would be the most predominant, but also Silver Book. This is what we have seen, especially by development of energy infrastructure and particularly of renewables. Big renewables projects have been built in private sector based on the FIDIC standards. Anticipated trends in reconstruction in Ukraine. We do believe that the reconstruction will demand substantial funding from domestic, but more from the international institutions and donors. And again, as we have seen, the international organizations, they will require best international practices, and FIDIC definitely belongs to these practices. Prevailing role of the public sector. So the majority of reconstruction projects, they endeavors will focus on the public social projects such as restoration of critical infrastructure, energy infrastructure, which is already ongoing, housing, which is already ongoing, schools, hospitals, etc. So since this will be the public projects, again, it's very likely to expect that these projects will be financed by the international institutions or donors, either directly or indirectly through Ukraine. And again, the FIDIC standards will be expected to be used in this kind of project. Labor shortage and requirement for international expertise. This is something not to underestimate. We have been already facing in Ukraine a shortage of skilled and experienced professionals, as many of them have left the countries when the war started, and especially those who are familiar with international projects, they were easily incorporated wherever they would go, and we believe that after the war there will be again a huge need to bring new forces into Ukraine, and if these are the professionals who used to work with FIDIC standards, again, I think that when they come, be it public or private sector, they will definitely use what they got used to, including the FIDIC standards, and then standardization of contract work. So we want a quick recovery of Ukraine, a quick rebuilding of Ukraine, and standardized forms such as FIDIC would definitely facilitate. It is important to mention that FIDIC cannot be taken over as such in any case for a Ukrainian project. So Ukrainian law differentiates whether you may use the Ukrainian law or not Ukrainian law to the contract depending on the contract's parties. So when we have parties to the contract just as domestic parties, you have to use the Ukrainian law, and then obviously you would have to adjust the FIDIC to Ukrainian law, and that brings certain challenges with it, which I will be addressing in my next slides. You may still turn to international arbitration, and I'm sure that in the next panel you will pick up also these issues when you have Ukrainian parties, but one of the parties is a party with international investments, and you would turn to international. You would be able to turn to international arbitrations. There are some certain aspects to consider too. When one of the parties is a foreign entity or is a representative office of a foreign entity, obviously, if you have big reconstruction projects which go over 6 months, typically under most of the bilateral double taxation treaties, that would mean that the parties have to have presence in Ukraine. If this is a foreign party, that would be a representative office of such party. In this case, you may turn to foreign law and international arbitrations without any reservations. You would still have to consider some mandatory regulations, but you would have, if you turn, let's say, for English law, you would have all the flexibility, which is not always given under Ukrainian law, as this is a codified via a country of a civil law, and we have our laws also codified and mandatory regulations to be followed. Yeah, here it is a slide actually. What are the main sources governing the contractor agreements in Ukraine? This is the civil and the commercial code, of course, which are governing the construction contracts rather on a high level. And then we have a special regulation passed by the government of Ukraine, which is called General Terms and Conditions for Conclusion and Execution of Contracts for Construction. This is more or less actually something similar what FIDIC is, as this regulation provides for typical provisions which the construction contract should have. And if you have 2 Ukrainian parties, you must apply this regulation and you must comply with this regulation. And if you would like to use FIDIC, then obviously you would have to adjust FIDIC in a way that it also complies with this regulations. And then some, which could be, as again mentioned by the Duna, reflected in the particular conditions to the contract. And here you would have to look some formalities for conclusion of the contract, which are in this regulation. There are also listed essential terms and conditions, which must be in every and single contract. I would say in the FIDIC they are, but some, again, peculiarities would have to be considered that to make sure that all the essential terms and conditions requested by the government resolution are considered. There are, of course, features related to the permitting documentation to be reflected, but this is well captured from the FIDIC form. There are some differences in liability of the parties to be considered. Also features for accepting the work and also the warranty period, as they have some special regulations, so they would have to be reflected. And finally, if these are public sector contracts, then peculiarities of this sector would have definitely to be considered. Yeah, here are some more specific terms when you would adjust the FIDIC for Ukrainian purposes. So we would have to determine the details of the facility under the construction. describing this maybe in a more formal way, which is also important later on when you finish and when you go to register this facility as a real estate, that it would have to comply first with the requirements of the governmental resolution, but also help later on to have a smooth regulatory process of commissioning and registering the finished facility. Design clause, where you need to define who is responsible not only for the design, but also for an independent audit of the design. This is something special in Ukraine. Every design has to be independently audited if the facilities are of higher complexity, and this is typically the case with the infrastructure projects. So you would have to, in Ukraine's so-called CC2 and CC3 facilities. So you'd have to define who is responsible for this audit and make sure that this independent audit is taking place. This is again the precondition for the permitting documentation, which in Ukraine allows to start the construction only after receiving the construction permit. And here you would have again to reflect this regulatory framework in the agreement on the one side, on the construction permitting side, but also on the commissioning side. As an example, Ukraine has its own regulatory definition of commissioning, which is typically not the same what you have as a commercial commissioning under FIDIC or in a commercial sense. That's why you would have typically to bring two definitions into the contract. One is the regulatory commissioning, and then one is the commercial commissioning, just to differentiate that you capture the differences you have in the Ukrainian legislation. Warranty liability, so as an example, warranty liability of producers, and this would be, for example, the silver book when the contractor is responsible for the design, for the delivery, for the installation. You would have to be aware that if you are the producer, you cannot exclude or limit the liability of the producer. And that causes serious issues to some of the projects where your project mainly is pre-produced equipment and just has to be put on foundation. That can be a very important topic to consider. Mandatory defects notification period, again, for instance, the warranty period for facility operation capacity for construction projects in Ukraine is mandatory 10 years. You would have to keep and reflect this in the agreement. And then variations, Ukraine legislation establishes special and priority rules as to the variations in the agreement, which do not always match with what you typically have in the FIDIC books. Implementation of the public sector, as I mentioned, it is expected that the public sector will be the main driver in the reconstruction, and some of the peculiarities here have to be considered. So typically it would be very difficult to use yellow or silver book, and you would rather be able to use the red book. Why? Because the procurement process as such requires that there is a basic design prepared, and this design is not only prepared, it's also independently verified, and not only the design, but also the cost part of that design. So these are all the mandatory provisions, and how you do this cost audit and cost definition. It is regulated again in the mandatory national standards, so you have to apply these standards, which again not something what is practiced internationally. It's pretty formalized, and you would have to consider this. The same as then with taking over the works and the goods. You would have to make sure that this corresponds with what you have had in your design, in the cost part, so that the goods and works you are taking correspond with the goods and works and prices you have listed in the design. So there's a pretty much of formalities put on this kind of the projects, and makes these projects much more complicated, I would say, than you internationally would typically expect. And then, of course, definitely you have the mandatory requirements for public procurement only in a few cases. Now, during the war, again, it's a bit different. You may abstain from the public procurement and sign direct agreements if there is a good reasoning for this. worth to mention that if you would have IFIs involved in the project, then you would have you could skip the use of this national estimating standards, or use actually simplified form of reporting, simplified form of preparing the cost part of the project, and also taking over of the work. So bringing it closer again to international standards. Yeah, and navigating the challenges, so just the outlook. Efficient reconstruction, the centralized project manager for enhanced collaboration. This Ukraine has made already the first step. I believe this is crucial for our reconstruction. So Autodor has been transformed into the state agency for reconstruction and infrastructure development. By the way, also mainly because it had the structure had so many projects done based on FIDIC standards, and it is expected that the personnel there is aware of how to use FIDICs, and hopefully is better placed to use these forms in the reconstruction period. Structuring complex public projects based on international framework agreements. As I already mentioned, using the FIDIC models would help on the one side to unify the approach within the reconstruction on the one side. On the other side, that would actually match the expectations of our donors and IFIs, who are mainly going to be the at least for now and for next year's the providers of financing. Yeah, and then obviously enhancing understanding of FIDIC contracts in Ukraine. That would help to overcome certain misconceptions about the use. Sometimes you may hear even from lawyers that FIDIC cannot be used in Ukraine. And this is, when you hear this is mainly actually because of some misinterpretation of FIDIC regulations. It is clear that FIDIC can be used both either as a Ukrainian governed agreement with some adaptations to take and to bring into line with Ukrainian civil and public law requirements, or it can be also if one of the party is acting as a foreign party, as a non-Ukrainian party, you can do it based on other laws, which could give you more flexibility, where you would still have to consider, of course, the mandatory public requirements in Ukraine while implementing these contracts. So thank you very much for giving me the floor, Anna, and then back to you.
Thank you, Alexei. Just 1 second, I'm checking whether we received any questions. No questions for now. Thank you very much for your exciting presentation. It's like, I think that we can do a separate webinar on each of your slides. A lot of useful information. And now we are turning to the successful operational contract management. Aisha, the floor is yours.
Thank you, Anna, and thank you to the organizers for inviting me to take part today. It was very interesting to listen to Daduna and Alexei, because Daduna was able to set out all the available tools that FIDIC offers in standardization and best practices globally on infrastructure projects. And Alexei highlighted the key utility of FIDIC, that it is structured in general conditions and particular conditions, and you have to do due diligence up front. Hopefully you align the FIDIC contracts through the particular conditions before you sign the contract, and FIDIC envisions that is required, and so therefore this general conditions is the particular risk allocation approach, and then you customize your project through the particular conditions to the applicable jurisdiction and your project contours. And it was very interesting to listen to Alexei saying that want to have a centralized approach to project management and execution of projects. And I think what that does for Ukraine is helps optimize efficiency in setting which particular conditions are required for application of Ukrainian law, which particular conditions are required for application of public procurement law in Ukraine, and which particular provisions. And so those two would be almost standardized across all of the projects. And this, I think, can really aid in the efficiency of rebuilding, because you only do it once and you learn from the issues. But then what's left is the developing particular conditions for the project-specific contours. And I think that makes it a much easier exercise, and makes the FIDIC contracts much more approachable. And I'm making sure that I actually can. There we are. So I want to take a step back and talk about why are we talking about construction in itself, and why are we talking about why is 30% of the ICC caseload in dispute in arbitration construction, and why do we need standardization? Well, if we think of construction projects, they're of course multi-year projects. Of course, there are a lot of specialized trades and industries being brought together to accomplish a certain project. But if we think about them, what could differentiate them from other types of projects is risk. Risk is inherent in every phase of a construction project. And you have to, you don't have the luxury up front to know every risk and define it. You actually, if you look at a construction project, it anticipates the type of risks and allocates them. It says, when I say allocates, it defines who is responsible for carrying that risk. And so we'll see mechanisms in a construction project of how, if a risk eventuates, if it comes to pass, the construction contract will give you a recipe or give you machinery of how to deal with the adjustment of the contract in terms of time and cost in terms of that risk. So if the contractor is carrying a particular risk at contract signature, there's no adjustment. The contractor accepts at contract signature the cost and schedule impacts of a particular risk eventuating. Whereas if the employer maintains that risk, and we talked a lot about the FIDIC Red Book, and anybody who's familiar with construction projects, we think of unforeseen site conditions. If when we start excavating, we encounter hard rock, and who's going to pay for that extra time and extra cost if it's more arduous because of hard rock, different than what we anticipated? In FIDIC, the Red Book, the employer maintains that risk, and then there's a system by which you adjust the contract. There's a procedure and a system by which you adjust the contract during the contract execution itself. So what does that say to us? It says when we have a contract, when we sign the contract, we have to understand the procedures and the mechanisms that are in the contract, that are provided for in this construction contract. And as Alexei clearly pointed out, we understand contracts don't sit alone. They sit within a particular legal framework. And we have to do our homework and understand that, because the only way we can rebuild Ukraine, whether we use a FIDIC contract or any other form, or a bespoke contract, all the parties have to know what is in the contract and how that interfaces with the applicable law during execution. And so you have to get everybody on the same page. And then you can think about the success of your project. And Daduna has clearly pointed out that FIDIC conditions have their 65 years of history, have a lot of background in anticipating the general risks, and those are the general conditions. They provide for particular conditions of particular application, so that the procurement agency or the buyer or the employer has to prepare those before they request for tender. And then the parties sign their contract. But as we know, there are certain knowns, and that's the party's original bargain. So I'm going to build a road for X. But then also there's known unknowns. I know that I might encounter more arduous situations that can cause delays and that can cause escalated price. How am I going to deal with those? The contract usually gives you the procedure in there. And then there's unknown unknowns. And if we think about rebuilding in Ukraine, we don't have, Alexei mentioned doing things in a standardized fashion so we can do it quicker and have rebuilding in an expedient fashion. We know that unfortunately, with what Ukraine has been facing over this period of war, you don't have the luxury of this detailed upfront planning sometimes. So you have to insert a mechanism, a way to have structured discussions to resolve these unknowns as your project is continuing. You can't just stop, because if we're going to rebuild Ukraine, the projects actually have to be successful. And the only way you're going to be successful, yes, if you've done your risk analysis, you know your project strategy, you know you've chosen the right form of contract, you've chosen the right FIDIC Red Book, you've drafted the right particular conditions, but that's not the whole story. You're going to have to ensure that parties understand that this real-time administration of contracts has to put issues in a way that you can effectively manage issues and have identify the issues and have a structured dialogue during the project execution. And so you're going to need to think about job site real-time resolution of issues, because if you encounter hard rock, you can't stop the project, go to arbitration, get an arbitration award, and then come back, and that's not going to rebuild anybody. Least of all the situation with Ukraine. So, and Daduna had highlighted that this clear risk allocation in the FIDIC contract, a possibility of tailoring your contracts to particular conditions, but then in tandem with all of that, a realization that the contracts cannot anticipate all issues and the contracts will be adjusted in terms of time and cost as you administer them. And so in tandem with this, you have this multi-tiered dispute management, and arbitration is only a final step. So what you're trying to do is give the parties the best chance to have a new meeting of the minds in how to deal with a late drawing or antiquities that weren't expected, or when you have ordnance that have not been exploded, how do you need to deal with those during the rebuilding process? Because you can't necessarily have swept all the mines that might have been placed. So you need to anticipate and have procedures to deal with known unknowns, but you also need to have a structured dialogue and a way to manage issues and conflicts as you go along. And FIDIC has this multi-tiered dispute resolution process where you have the engineer, the dispute adjudication board, making a decision in case the parties don't agree with the engineer's determination, and a possibility for amicable settlement. And all of that is before arbitration ever can commence. And there's always a possibility to have a structured dialogue and have a meeting of the minds for the parties to reach a settlement before an engineer makes a determination or before a formal referral to the dispute board. Now, we talked a lot about a lot of IFIs around the world, and some, as the Duna mentioned, some of them mandate FIDIC, others suggest FIDIC, and money, the colors of money drive a lot of the regulations that you need to use. But this idea of having multi-tiered dispute resolution clause and getting on with the project and having real-time decision-making is not new. I'm reminded of the standard contract of the American Institute of Architects, which was published in 1888, so a little older than the 65 years of FIDIC. But it also had a multi-tiered dispute resolution clause, because if you are going to rebuild, you've got to get on and focus on successful projects. So what Alex mentioned in his keynote, one of the two documents that were published this summer, the report on settlement and arbitration, and I won't touch on that, but I think this ICC guide, and I know the second panel will delve much more into dispute resolution and effective conflict management, but just want to highlight the second of the publications Alex was talking about, this guide of effective conflict management, because it's structured in three parts. It introduces what the parties can do upfront without the assistance. What do they need to do in planning to have a conflict management approach or an ethos in their organization, such that we can reach what Alexei talked about, this collaborative contract administration and focus on project success. So it gives a section on unassisted conflict management. And then it talks about assisted conflict management. And what is meant by assisted conflict management is if you have a third party neutral. So we see the FIDIC, where the engineer is a third party neutral, the dispute board is a third party neutral. So that's assisted conflict management. And so it introduces the spectrum of the ICC tools and tries to use infographics to make them accessible and understanding to the parties, and focuses on the differentiation, what you want that third party neutral to do for you. If it's only mediation, you just want them to facilitate the dialogue, or do you want a non-binding evaluation? So it just kind of, in a quick infographic, gives the ideas, and then talks in detail about the roles and the focus of the service that's provided. And if you see the FIDIC contract, it's a multi-tiered dispute resolution clause in which you put a variety of these tools together in a certain manner. So even if you're not using a FIDIC contract, or even if your donor funds don't mandate FIDIC, or they possibly mandate a different type of standard form contract, international standards are good, but the employer, in this case, the Ukrainian government through the IFIs, has to give some upfront thought to how they're going to not only manage the contract for success, but operate an effective issue management and conflict prevention of escalation, real-time dispute management and resolution. And I just want to invite the parties, I'll stop there, but I really, this is freely available on the website. And I think it gives the first principles, because a lot of times people say, the dispute board, FIDIC dispute board is too expensive. Why would I have three? Why would I have a standing dispute board? This ICC publication can be used in tandem with FIDIC to understand the beginning principles of what it is, or be able to be in a position to modify in a more appropriate way for the administration or the procurement agency, something that's more appropriate through the particular conditions for Ukraine. So I think it's important to think of the FIDIC rules. They're there. They give a standard. But it is important to understand how you can use the utility of particular conditions to best meet your needs. So I'll stop there.
Thank you very much, Aisha. It's like really very impressive how much information you shared, and it's really it's up to the lawyers, to the business to educate themselves and to be able to choose the best solutions. We don't have any questions, so if you have questions to each other, otherwise we can invite the second panel.
Well, I think it's I have a question to each of Duduna and Alexei, if they don't mind, and you don't mind, Anna. I think it would be really how does one choose between the various forms of FIDIC standard forms? You mentioned so many, and you mentioned the three: the Red Book, the Yellow Book, and Alexei also mentioned the Red Book and Yellow Book and the Silver Book and Green Book. And how does one approach selection of an appropriate standard form?
Shall I go first, or?
Yeah, Duduna, I think you're best placed on a general response, and I may add if
Thank you. Thank you for the question, Aisha, and thank you very much for a very interesting presentation, diving into the details of very, very important aspects of risk and the selection dispute management. As per your question, how one choose the right FIDIC contracts, I may also start by, I'll try to answer the question, but also try to refer the parties to the FIDIC procurement guide, which provides the guidance on the selection of the contracts. It's been published in 2011, if I'm correct, and that document might be useful to help in selection of the specific form. In general, the parties will have to look at the type of the work, will have to look at the size, the scale, and particularities of the project to come up to the specific requirements of the project, and then look at which of the, say in this case, the FIDIC contracts provides the best tool to address, whether it's a design or whether it's construction on the required, and how the risk allocation in this case could work better, who is better able to provide the design, and so on, and so on and so forth. In doing so as well, for example, in the case of the Ukraine, what could be very useful is engaging the consultants, maybe under the White Book, to do the specific assessments of what needs to be rebuilt, what needs to be, so what are the hazards and so on the specific sites, and then based on the advice by the consultants to go about the selection of the specific contracts that could be implied, starting from the whether it's a long-term procurement, it's a short-term procurement, or what system could apply. I hope that answers the question.
It goes really far in helping people, helping understand what, you know, how do you navigate all these many forms. Sorry I have a question for Alexei, but I turn it over to you, Anna, if I may ask the question or not.
Yeah, sure.
Alexei, can I ask you another question that is not about this?
Sure.
I noted on one of your slides, you talked about variations, and you talked about not applying, and maybe I misunderstood, but not applying the public procurement laws. You can be in a situation where the public procurement law would not be applicable in certain situations, because I saw the Civil Code and the Code of Obligations on Contracts, and
what variations? Yeah, variations was about something different. Variations was that you're not always placed to do the variations as you would like to do, because there is this formal process of approving, verifying the design, and also the cost part of the design. So just to variate as you typically would have under FIDIC contract is not always possible, because you have to introduce the changes to the cost part, if this is, for example, variation with respect to the cost, and then again verify this with the independent audit. So this was the part with respect to the variation. As respects the procurement, we have Ukraine has actually a very modern procurement law, which is aligned with the EU law. But the fact that we have an ongoing war, and the fact that sometimes we need either to keep the things low in terms of publicity, or we need to speed up with some projects, gives the public authorities the right to procure directly, meaning without really keeping up with the procurement regulations. There is, however, no obligation to, if it is not a state secrecy, to publish the results of such agreements. So it's not a procurement, it would be really a direct agreement, and not even a direct agreement within procurement. So our law, of course, knows procurement as a tender, as an auction, but also as a direct agreement. But still, the direct agreement, there is a process, right? So you could skip that process. You could have the agreement signed directly with the supplier, based on the martial law regulations which are in place there. Still, what we see that all the public institutions, although they are not obliged to imply the procurement, they still want to imply the procurement wherever they can, in order to show the transparency in the process, and not to be accused later on that they just use the martial law to avoid the public procurements. So yeah, that's two different aspects. And just shortly as how we choose the book, what typically our clients ask us what book to choose, and then our suggestion is again very often based on where the project is, what the intentions are. And after we explain to them also this formalized process we have, not only for construction, but also for design. So since there is this formalized process, and for example, you cannot use the silver book with the public procurements, because the public procurement is done in a way that you have already, you must have a design, basic design there. You must have some cost defined, and then you go and you procure. So you cannot procure just the, let's say, general idea, as you very often have this with the silver book. Or you could use this, but that brings a lot of complexity later on, adding to the agreement information after the procurement. So which again makes more or less the use of the contract obsolete. Better to split this then into two parts, right? The design process, then definition of all the conditions for the procurement, and then the procurement. So depending on these aspects, and then with the private project, of course, you may definitely use the silver book in these cases, and this is what we have had also in our experience. So yeah, depending on the situation, on the process, on the requirements. Actually, these are us who typically advise what we believe is the best place. A very simple answer to this.
That's very helpful. I mean, I think it also highlights that you need to do your homework, and you need to be well informed of Ukrainian applicable the applicable law and the FIDIC forms to be able to choose wisely and tailor wisely. So thank you for that.
Indeed.
Thank you.
Yeah, thank you for your questions.
I may add to that, Anna, is in FIDIC what we are considering at the moment is for with the collaboration to produce the national particular conditions for Ukraine to help, as Aisha has mentioned in its presentation, and Alexei as well, to produce the standard particular conditions that would be applicable for in many circumstances, with then tailoring the project. So we see that this might be very helpful for the industry in application of the contracts, and we're exploring at the moment. We'll be looking at that more in the near.
Yeah, definitely. The standardization would really contribute to the facilitation of the projects and agreements negotiations.
Thank you.
Thank you, everybody. So it's a lot of information, a lot of insights, and we will need to follow the developments. Now let's give the floor to our second panel. Thank you.
Thank
you very much. Okay, so now, thank you, Anna. Thank you, colleagues, for very interesting and informative discussion about application of FIDIC contracts in general and in Ukraine in particular. And now let's turn to the topic of potential disputes in this area. So the topic of our panel, what is the best option to resolve construction disputes arising out of a rebuilding project in Ukraine? And we will discuss this topic with three stellar speakers. I will briefly introduce them. So Luminita Popa, managing partner at CCU Popa Attorneys in Bucharest. Luminita is also a member of the ICC International Court of Arbitration, member of ICC Commission on Arbitration and ADR, and fellow of the Charter Institute of Arbitrators. We also have Sergei Melnik from Paris. Sergei is Deputy Counsel at the ICC International Court of Arbitration, part of the Secretariat's case management team dealing with the parties from Eastern Europe and Central Asia, so-called ICA7, and this covers Ukraine as well. Sergei is a Ukrainian national and has triple qualifications in Ukraine, in France, and England and Wales. And last but not least, Volodymyr Yaremko from London now, Senior Associate at Mayor Brown in London, admitted to legal practice in Ukraine and in England and Wales, included in the FIDIC's present list of adjudicators, and also a fellow of the Charter Institute of Arbitrators. So, let's begin with some background and specific features of the disputes in large construction projects. So, Volodymyr, would you like to start?
Sure. Thank you so much, Olena, for inviting. I'm very pleased together with Luminita and Sergei to share some thoughts on this topic, and we'll briefly start. So please feel free to interrupt me so we can make it more collaborative, about specific projects in construction projects, features. I think construction projects, of course, differs whether it's private or public. But when we speak about rebuilding, at least a significant part we understand will be public. And when it go public, it's go larger. So we speak about infrastructure, not about only some, I don't know, renewable energy projects, or not only about some factories, which also may be large, but we speak about large bridges, long highways, we speak about ports, we speak about airports, and of course housing, residential construction. So, but still a lot of need to be rebuilt, and it's involved large contracts and with large amounts of works done. And as was discussed in previous panel, very important to plan it in time, but sometimes not enough time, especially when you go fast in rebuilding. And so basically, I think the features are, so those contracts are large. They are complex, a lot of factual complexity. When they go to disputes, there are hundreds, thousands of documents. some of them may be in 1,000 pages, so it's very voluminous. A lot of stakeholders involved. In addition to the employer, contractor, there may be some additional players like engineer under FIDI contracts, some suppliers, some designers, some experts involved, some supervising authorities, some subcontractors, banks, sponsors, some related stakeholders, which also may trigger additional disputes and set of disputes, multi-party proceedings involving. So, and that is why basically I think construction industry, which is very dependent on cash flow and time is a money, especially in construction, develops and want some not only like one way to resolve dispute, but multi-tier way to resolve dispute, which starts from engineer to filter some of the issues and some resolve. And so then maybe if parties agree and it's enforceable and doable in specific jurisdiction, some adjudication dispute boards. And finally, it may go to the courts, or usually in international practice, it goes to arbitration, international arbitration. And when it goes to arbitrations, there are also requirements similar as to the contracts. So the arbitrators have some time, need some time. It's not possible sometimes to meet deadlines, which are in the courts usually limited, deadlines, and require from arbitrators to be able to understand this technical complexity and to deal with it. And ideally, of course, especially the parties wish to be experienced not only in construction, but in specific industry type of construction. And sometimes the parties, contractors, especially experienced worldwide, would like the arbitrators' experience in construction in specific area, in specific region. So, and this is maybe very challenging and require wide pool of arbitrators, experts, and rules to be engaged. And I will give a floor now to my colleagues, maybe to continue.
This is my suggestion. So let's just wait for a minute before we turn to the options of dispute resolution. So Sergei, Limonita, any comments, general comments on background of disputes in this industry?
The floor to Limonita first.
Well, only one comment on my side, because I fully agree with the features that Volodymyr was indicating, and they are definitely the most important or the specific features for construction arbitration. Only one thing I would stress, because I think it was mentioned, and this is the fact that in a vast majority of the cases, when the dispute arises, the project is still under being built. So it is it's in the middle of the project, or sometimes even at the beginning of the project, which is quite distant from other arbitration cases as we know them, when the contract is ended, the parties have entered into a dispute and everything stops or is being ended. In large infrastructure and large construction projects, the dispute may arise while the parties have to cooperate, have to continue the project. So I think this particular feature is extremely important, or is relevant when we discuss about the importance of arbitration in construction, for construction disputes, because arbitration is giving the flexibility, and also the FIDI contracts have other ways of dealing with the disputes while the project moves on, without affecting or trying not to affect the good performance of the project while a dispute is being resolved.
Yeah, not an easy task, I would say, but yes, this is really one of the features. Sergei, would you like to say anything?
Yes, sure. Yeah, I would like just to add maybe on the issue of flexibility offered by different fora for resolution of disputes in construction area. I've seen a couple of situations, a couple of cases where the parties would initiate arbitration before the ICC, and in the middle of the arbitration, either on their own will or by the order on the request of one of the parties and confirmation by the arbitral tribunal, they'll go back to the AB proceedings and try to resolve the issue there. Sometimes the case will be over. Sometimes the parties will be able to actually follow the decision of the DB, and that's it. Otherwise, parties are also free to come back, because usually the proceedings in such cases are stayed until further notice. So this is just to highlight that indeed this combination of different, also like in terms of hierarchy and timing of different types of dispute resolution, starting with engineer, going to DAB and then to arbitration. It's not even set in stone. Parties can come back and decide as they please, meaning the ultimate goal is the efficiency and cost efficiency also, because obviously arbitration might be more expensive in terms of document production, legal costs, etc., than a DB proceedings or even bilateral negotiations between themselves. And then another comment is also raised by Vladimir. It struck me a little bit because I recently had an example in one of my cases is about specialization, because really now the parties become very sophisticated, and sometimes they also leave, either they do their own due diligence or revert to services of the institution on selection of arbitrators, and sometimes they have very specific criteria, for example, experience in some particular subsectors of construction, also with applicable region or even law of the specific country, meaning that now we see a quite complex and also diverse world in construction dispute resolution, which shows that it's actually quite mature and quite efficient.
Thank you, Sergey. I just wanted to add, probably this is very obvious, but still for the dispute resolution and importance of construction projects are very lengthy and time consuming. And this means some construction projects might be like not even years, but decades long. And this, of course, requires resolution of some intermediate or disputes arising in the process of that construction before the project is over. Okay. So we have already discussed a bit about the options of dispute resolution. And in previous panel, it was already mentioned that depending on the nationality of the employer and constructor, we might have different options of dispute resolution in Ukraine, because we might have a situation, for instance, of purely Ukrainian parties. We might have situation when one of the parties has certain like international investment, as we call it, or a shareholder from another jurisdiction, and we might have a situation when we have one of the party which is absolutely foreign to Ukrainian jurisdiction, and this might have implications for applicable law and for dispute resolution. So, Volodymyr, could you please start with the options for Ukrainian rebuilding projects in this regard?
I think I will start with that with some my as a I would say recognition, that I'm really happy how Ukrainian arbitration law develops, and how Ukrainian arbitration community develops. And this event is one of the and such kind of events which are regular as examples of this, and also reforms to the Ukrainian arbitration law, which happens within the last decade. And most recent judgments of the Supreme Court and involvement of Ukrainian arbitration community, including Ukrainian Arbitration Association, in these reforms is a good example. And I think now Ukrainian arbitration law is quite flexible and in line with similar and worldwide best practices, and there's quite a few very suitable and for arbitration and available, which is also good decisions of the courts. So basically, I think when the project is in Ukraine, and it's large project involving international financing, it will be most likely go to the arbitration. The question is to which arbitration, and this is and when lawyers ask this question, they look who are the parties, because the project is in Ukraine, where there is foreign element, and who are the parties. And basically, when the parties are a foreign party involved, directly or indirectly via some representative office, which is quite common in construction to act via representative office in Ukraine for foreign contractors. So basically, it's local Ukrainian arbitration law provides for such directly for opportunity to go to arbitration in Ukraine or abroad. Yeah, so there's quite a big flexibility. But when there are only purely local two entities, and maybe even there are some foreign entity, but quite far upon the structure, yeah, not directly. So it may be harder to substantiate possibility to go to arbitration, which may be called like domestic arbitration, basically even called domestic international arbitration. Yeah. So basically, it may be some issue due to the Article 1 of the International Commercial Arbitration Law in Ukraine. So, but recent practice of the Supreme Court, I think, is good to say that so Ukrainian entities can go to foreign arbitration, international arbitration. Okay, so it's okay under Ukrainian arbitration law. Of course, subject that it's okay also as the law of the place of arbitration, which is usually the case. And I think in this regard, when we speak about ICC, which is default choice and the FIDI contracts, it's good that I think in the main point is global reach. Yeah, so it's very, very global, and it's known to contractors from any region of the world. And I expect that contractors for many regions in the world will be interested in come to Ukraine. And it's not only about Paris, yeah, and the seat in Paris, yeah, which is also not a bad choice, yeah, but you can have ICC and they can have seat in other jurisdictions, including in Ukraine, even, yeah. So I think this is the difference. I would like to recognize that it's quite flexible, especially when you speak about some international arbitration now, foreign, you can name it.
So thank you, Volodymyr. And I know that you have different experience with different arbitral institutions, different rules, and Ukrainian court as well. So how all this plays, how this option works, what are the pros and cons of each option for the project and for the users?
Yeah, unfortunately, my experience in construction is also like in general commercial contracts, that those clauses are usually not pay much attention when entering the contract. Yeah, and even sophisticated contractors sometimes see themselves in some very exotic institutions and exotic limitations to arbitration in respect of language. It's maybe in respect of choice of arbitrators, even so, in respect of this arbitration procedure. So I think so. My experience is that it's worth to consider it in advance. Yeah, but because I have seen FIDI contracts which were very far from default provisions, which is okay, and it's good that there is such freedom, yeah, particular conditions. But I might say that FIDI golden rules, yeah, just a few golden rules. They say that be careful with changing this. This is one of the golden rules. Yeah. So, but anyway, I have seen FIDIC disputes result in local arbitration institutions, including in Ukraine, but not only in Ukraine. And which are not very familiar with such kind of contracts, which is something new. I have seen also in courts, including Ukrainian courts, and I have seen even in under UTITRAL ad hoc rules. And I have also seen when there is court, but the parties try to change it. So they understand that the court will not meet their expectations, both parties, yeah. So they will not resolve the dispute. They will have a never-ending dispute, yeah. And they won't have more projects. Cooperate won't. It's not in Ukraine, this project. Yeah, but still I think it's very relevant. And they agree on expert determination, basically, and then to go to arbitration. Yes, with this already, basically. So basically they rejected this FIDIC way, but then after the dispute arose, they constructed it back, like the dispute resolution mechanism ad hoc. But so my experience is that the parties are free to choose. But of course, the easiest and familiar way for international contractors when entering Ukraine will be go the way they know, and the default way is ICC, and all other options involve some may involve some issues. In particular, I would say courts. Yeah, courts. Are very unpredictable, and it's playing not in your territory usually, yeah, for foreign, especially contractors. And I think for courts, I would specify, maybe my colleague will add, but especially in Romania, I'm wondering what is experience. But I think in courts, we can have a few review on merits, and in Ukraine you also can have not only two, but then next cycle we can go a revision. You can back to the first instance, and this is not something construction disputes will benefit from, because they very you need better to do one good, but and that's it. And that's and therefore you need good framework, good tribunal, and good procedure, and some flexibility. Then revise merits twice. There is no. It's very expensive and and timely, and not efficient to revise merits twice. And of course, it's hard to find judges who will be ready to consider those disputes because of their busyness, because of the some limitations in the procedural codes. And again, we come back to flexibility and limited pool of available arbitrators. And the final point I only mentioned about courts, that experts very important, I think, in construction disputes, and I found not only in Ukraine but various jurisdictions that the rules on experts in litigation, local litigation, are less developed and less flexible. Also, again, about flexibility, and I have quite a few construction arbitrations, and all of them involve experts, and usually more than one expert. And I think it is. But I will mention one more point. I thought it's the last one, but it will be last. But the court, I think the cost, of course, for us as lawyers and for our clients, I think very important how arbitration institution against other institutions or courts respect the costs and appreciate the cost of these proceedings, and the possibility to recover those costs. So basically, maybe we'll discuss later about myths of some arbitration at the ICC, and we can come back to it again.
Yeah. Luminița, I know that Romania is a kind of regional champion, if I may so say so, in number of disputes related to various construction projects, and in using ICC arbitration as well for their resolution. Romania has already accumulated like decades of experience in the area, which might be very relevant for Ukraine now. So could you please tell us about the situation in Ukraine and about difficult choices, or probably some practices developed? I'm sure that could be very interesting for our audience.
Sure. Indeed, I think Romania is now a source of jurisprudence, let's put it this way, in terms of construction arbitration, not relevant not only for Ukraine. I identified no referrals to specific cases which were Romanian cases in this and in different, parts of the world now, because again, FIDI contracts and construction arbitration is quite prone to identifying and then multiplying the same rationale to distinct disputes, but with similar aspects. Indeed, I would say that there are probably now accumulated around 20 years in which FIDI contracts have been used in Romania. Romania joined the European Union in 2007. By then, I think that there were already around 10 years for different Romanian entities, being local authorities or central authorities, the Ministry of Transportation or the Ministry of Development, different institutions, which were already using FIDI contracts, primarily because the funds received for those projects were either EU funds pre-joining the EU or World Bank or other international financing institutions, which imposed the FIDI contract. And consequently, again, by 2007, there were approximately 10 years for different institutions using FIDI contracts and using different types of FIDI contracts. After Romania joined EU in 2007, there were again approximately 10 years in which the FIDI contracts were quite heavily used by different institutions, public companies, for construction of roads, for construction of infrastructure, public works, or railway works. So different sort of public works. Obviously disputes have arisen. Obviously, being again a country in which the need for development was quite advanced, but at the same time, joining EU and the need to accumulate to adopt the European legislation was also leading to some sort of necessary clashes, but however difficulties, because European Union means adopting the EU legislation and having all the public bid and public auction and all the public procurement set of rules. So it's not an easy process, generally speaking, but what helped as and what were the aspects which made the adoption of the FIDI contracts useful was that, first of all, they were offering a sort of standardized contracts, which made the public bids and the competitive process easier because they were comparable. You can with FIDI contracts and the FIDI structure, you can have different bidders and you can have different projects using the same contract, and then their offers are easily comparable as compared to using, I don't know, a specific contract or a different type of contract. Negotiation, which is an important factor, what is also made easy or easier if you're discussing on a standardized on a FIDI contract, because parties come to the table of negotiation with already knowing we're discussing about amendments to the specific conditions, for example, but it's not the same thing like negotiating a new contract from the very beginning. And the third aspect, which I think and proved to be very important, was also the access to a dispute resolution mechanism, which was providing for a trustworthy arbitration institution with practice, with experience. And again, that was under the package of pluses and why adoption of the contract and then consequently of the dispute resolution system within the contract was extremely useful. As regards the disputes arising of the contracts, again, it was a natural process because it's a we're speaking about so different and so complex construction projects in a post-communist country, in the society, as generally speaking, is adjusting to this. So it's not generally a simple thing to advance and to, but I can say that as you and I have noticed, that everyone involved with the court and with the ICC knows that there were so many ICC construction cases related to Romania. They helped on one hand to build some sort of an institutional acquis in terms of dealing with construction projects. And on the other hand, indeed, they led to a practice and to a jurisprudence now on FIDI contracts, which were related to Romanian cases. What I would like to underline is that on the multitude of contracts that I've seen during this past 20 years, contracts within ICC arbitration clause, which then led to arbitration. It is important to underline that in many of them, the place of arbitration was Bucharest. The language of the arbitration was Romanian. The substantive law was Romanian. And I think that I have quite a few, or I am aware of quite a few number of cases in which the tribunal was composed exclusively out of Romanian practitioners. So you have ICC, but the Romanian input in it is extremely strong, and it is offering all the options for the parties as per their will. At the same time, there were cases with a place of arbitration in Geneva or in Paris, but in all of these cases, the substantive law was always the Romanian law. So there was a strong relationship with the domestic law, with the local law, and that again was checking, the boxes for the requirements of different public institutions, and not only. There are also constructors who were insisting for Romanian law and even for the place of arbitration to be Bucharest.
One last question before I ask Sergei. Sure. And are the Romanian courts supportive to arbitration or to different various forms of dispute resolution in construction projects?
At this moment, I would definitely say yes. Obviously, there were not necessarily ups and downs, but different approaches from the courts. But one thing is clear, and this was that they were supporting for the arbitration, for the recognition of the arbitral process, and for the arbitral awards. If there were maybe a wrong analysis made by some judges on an award or another one, it may happen. This is not a 100% surety, or let's say accurate. We all know that whenever you have two lawyers, we have three legal opinions at least. So it may apply also to the judicial system, but as a principle, yes, it is. And I could think, for example, also for a decision made by the Supreme Court of Justice in Romania, which was considering an issue which was quite widely discussed in international arbitration, particularly to FIDI contracts. More precisely, the way that a DAB decision can be enforced during the time that an arbitral tribunal is analyzing the merits of the case, or is analyzing if to reverse or not a DAB decision. And Romania has a decision of the Supreme Court of Justice saying that a DAB decision is enforceable by means of a partial award during the time that an arbitral tribunal is analyzing the merits of the case, which I think that it shows a supportive approach towards the way the FIDI contracts are being interpreted, and how the will of the parties in FIDI contracts is being recognized by Romanian courts.
Thank you, Luminită. That is very interesting. I'm sure that Ukrainian audience should be inspired by many insights you've just shared. Sergei, so a lot was mentioned about ICC as a default option in FIDI contracts, but there are so many myths and misconceptions about ICC, and probably also lack of understanding of all its benefits for construction disputes in particular. So what are those myths and what are the benefits of ICC arbitration?
Thank you very much, Olena. Can you see my slides? I just want to
yeah.
Okay. And then we move to the more general discussion. So just to show you, in terms of percentage, we have hundreds of cases. We're approaching thousands of cases, 1,000 cases per year now of high complexity arbitrations. And as you see, the highest sectors that we are getting as cases are construction and energy. And actually, a lot, if not most, of energy cases are also construction cases, because those are energy construction cases on energy infrastructure. It's just a matter of classification. We have to separate them somehow. But so basically, at least a third, and maybe approaching maybe 40%, between 30 and 40% of cases, depending on the year, would be construction cases. and then comes everything else. So in this regard, we can say that in terms of expertise, we know what we're doing, and when we're doing that already for many years, that meant that we developed in-house competence in the subject. Also for Eastern Europe and Central Asia, including Ukraine. And as Luminita mentioned, we obviously have a lot of cases targeting Romania, but not only, also Ukraine. We have several high-stake arbitrations, some of them ongoing, so we unfortunately cannot discuss the details, but just in general to tell that we have cases with Ukrainian law applicable. Parties are always free to decide that Ukrainian language may apply and that the seat could be also in Kiev. It's really, the full flexibility. We will not impose anything on the parties. So we can have, in theory, the same type of tribunals as in Romania, meaning all three Ukrainian speakers with Ukrainian language applicable and Ukrainian law applicable. At the same time, of course, knowing that an important part of these cases involve foreign contractors, there can be the mix that we see already in practice when you have Ukrainian law applicable, but the language is English, and you have various nationalities on the tribunal, and even in council side, where Ukrainian party easily chooses between Ukrainian law firms, also foreign counsel, or a mix of both, showing that everything is possible, and it also can target different projects with different complexity, meaning that we now have also a specific type of rules called expedited procedure, providing for cheaper resolution of disputes with now up to $3 million at stake, meaning that we are also equipped to handle not only multi-billion or hundreds of cases with hundreds of millions at stake, less big infrastructure projects, but also smaller ones like on regional size, regional scale. And we do have those already quite a lot, actually, and I'm personally supervising those since my start at the ICC almost 7 years ago. Then maybe just to touch other parts that already Volodymyr and Lenita touched upon about costs. I think it's important part to discuss for potential or current parties. We have also quite flexible approach to that. Obviously, we have a scale, as many institutions do, to have some guidance how to fix costs for the proceedings. But if the arbitration is quite straightforward, and especially if it's a lower amount at stake, as I described, you can apply expedited procedure. But even for standard arbitrations, if, for example, the case is quite high, we will limit the costs. We will not go, disproportionately high. We often fix the cost lower than average when we see that arbitral tribunal is well paid or sufficiently paid, and we will not impose, any extra costs on the parties, especially when we see that one of the parties is a governmental either body or state control enterprise, meaning that de facto the money they pay are the budget money of the country. So we're also obviously very conscious of that, and we will not impose unreasonable costs on the parties in any way. Yes, so this we described. Otherwise, we already have quite a number of jurisdictions. That's not only Romania, but also Slovakia, Czech Republic, for example, a lot of Polish cases, or in Central Asia, for example, Kazakhstan, Uzbekistan, Turkmenistan, where we handled various projects of different complexity in different areas. For example, stadiums, recreational centers, various hotel facilities, chemical production plants, energy production plants, both thermal and nuclear power plants. Honestly, whatever you can think of, it was only me. It's only my personal experience. If you count, the overall experience of ICC, I think whatever project you can imagine, we had it because of statistical, number of cases we handle per year. So we will be equipped, obviously, to handle more cases from Ukraine, and already have infrastructure for that. Another point I think which I would like to highlight is also the quality control that we have within the institution, which is quite a unique feature of the ICC. And obviously, court members, as you, Elena, they know how it works and actively participate in this procedure. It's called scrutiny of awards. Where after receiving the draft award, we will not send it directly to the parties, but we would have it looked through and verified by several layers of security, so to say, several groups of people. So the first layer would be a case management team where I work. We would look at the parties' submissions, analyze arguments made by the parties, look at reliefs claimed by the parties, calculations made by tribunals based on the arguments and submissions made by the parties, and also look at the general structure of the document, identify maybe issues with the reasoning, because, for example, the outcome is correct, but it's not sufficiently argued, meaning that there might be risks at the stage of enforcement of awards. If the enforcing judge finds that, for example, there is no evidence that would allow to reach this conclusion that tribunal reached. So we try to minimize all these risks by making comments that afterwards are passed to the management of the secretariat, which have a second look at the case. You already heard Alex, but we also have other members of the management who have vast experience in all types of disputes, including construction disputes. They will also identify additional issues and problems that might be addressed by the arbitral tribunal. And all of this will be also passed afterwards to court members who are themselves leading arbitration practitioners, partners in law firms, academics. Some of them are big authorities in the world of arbitration. We also have a separate category called an observer, where we had, for example, someone who is a legend, basically, in construction arbitration, Chris Sepola, for example, who would also have a look on FIDIC awards and have his own comments and opinions, which are quite useful often, from practice to identify problematic parts in the awards. Unless, of course, he has some issues of conflicts of interest, then we will exclude him from the exchange. So we also have this reservation always before sending anything to any court member. We will also verify that there are no conflicts, no hidden or apparent conflicts of interest behind, or any connections. And then basically, based on all these reviews from all these groups of people, we will have a final version of comments that are passed to arbitral tribunal, who will have to address it. And if the award of bad quality, we would actually not approve it, and we'll send it back with comments, asking tribunal to redo the draft, which is a rare occasion. Sometimes it happens, but it's quite rare. The usual scenario would be for awards to be reviewed, addressed, comments incorporated, and then the final version would be checked again by us, and only then will be signed and notified to the parties. So all these, and I should say that most of work, not only because of the proportion of construction cases in my team, but also because of the complexity of issues. Because often, especially in bigger cases, you have pages and pages of claims in statement of relief thought, meaning that submissions themselves are usually several hundreds of pages, and the supportive documents are thousands of pages. Just the relief itself is several pages, meaning that you have to make sure that every point is addressed correctly, properly calculated, nothing is missed. And sometimes even with star tribunals, big names who everyone knows, I personally found missed claims, for example. So if it would be some case without scrutiny procedure, it would be just missed. That's it. Here's your award. So it happens, but it's a human factor. It's a human nature. It's normal. That's why we have this procedure behind that would avoid these situations at the early stage without any impact for the parties. I guess that would be the main features that I can highlight for ICC proceedings.
Thank you very much. Very interesting. Colleagues, Leonida, Vladimir, would you like to add anything about misconceptions or benefits of ICC?
I can start with a few words. So I just can echo what Serhiy said. Yeah, it also reflects my experience. I would say that usually construction disputes, most of them, in addition to also some very specific technical issues, they're about cost and money, so extension of time and additional costs. Yeah, and it's fine. It's alive. Yeah, it's impossible to predict everything, and FIDI contracts provide for such possibility of extension of time, additional costs. But when it comes to the parties, but the parties try to resolve it. Yeah, the parties try to not to go to arbitration. They try to work. They want to work. They have common aim to complete the project. Yeah, and they're ready to usually to both employer contractor to waive something. Yeah, for such purpose. But when they go to arbitration, the main for them is of course cost time is also important, but the main of them is resolving this because they had already usually. Hundreds of letters, a lot of meetings, a lot of discussions. They know this dispute very good. Yeah, very good and very fact consuming. So they want to resolve this dispute, and I think this is basically comes back to the issue that they want a good framework, institution, good rules, and good tribunal who can do this job. Yeah, and of course it will be good to recover costs, and it's good that ICC rules provides for such possibility and understanding on global level. Yeah, global level, and of course it takes some time to resolve disputes. I think nobody should expect complex construction disputes to be resolved even in a year. Yeah, even in a year, if it's really complex and technical complexity and so on. If it involves experts are very busy, limited pool of experts worldwide, and they require times and so on. So I think so at this stage, when it goes to arbitration, the time is not so significant for the parties. They just want to have fair resolution of the disputes in a manner familiar to them, and by usually is something international, arbitration international, which is familiar to them.
Thank you, Vladimir. I would like to add to the audience that they could put questions in the chat box of YouTube, and we will try to pick up them later. But sorry to interrupt you. Luminita, do you have anything to add?
Only one comment. So when we're speaking about the myths and the pros and cons, we have to actually discuss on what we're comparing arbitration in construction to what. So which are the potential avenues for parties from which to choose? So it's arbitration court. Those are the two major. Of course, we can discuss about arbitration and which institution or ad hoc arbitration. But if we are to split only between arbitration and domestic courts, then we have to look to how long a case, a construction case, takes in front of a domestic court. It was mentioning before, the possibility to actually have several layers, and that's a certainty in all our jurisdictions, that you have several layers of any decision being potentially challenged up to the Supreme Court of Justice, who may terminate the decision of the first court, and you're taking the full circle all over again. And by now there have been probably at least 3 or 4 years. Courts are overloaded all over the world, but I think that systems like ours are even more prone to getting courts overloaded because of lack of resources, and just name it. So it takes a lot. It takes definitely much longer to move a construction case, which is complex, as we all have acknowledged up to this moment, which is extremely complex, to move it through ordinary courts, through all the layers that a domestic system, a domestic court is providing. And let's also not forget on the specialization of judges. There are jurisdictions, indeed, the Anglo-Saxon world is more developed from this point of view, where there are specialized courts either for construction or for certain types of claims. But that's a problem, in other parts of the world, and it is really difficult to train a judge on the job. It happens quite often, but in terms of construction cases, it is quite difficult, and the results are again more difficult to anticipate. And the third line is which is a or the third item, which is a sort of a combined issue between all of this time, money, and speed in terms of obtaining. Let's not forget that the construction agreements with an ICC clause and with an arbitration clause, or the FIDI construction agreements with an ICC arbitration in them, have again what I was relating to before, the flexibility for the parties to either stop the proceeding at a certain moment, go back and negotiate, or continue the project while litigating, or have some other options and potential shorter resolutions to at least parts of the dispute, which is quite difficult to be obtained in different systems of dispute resolution.
Yeah, true. In Ukraine, we have automated system of cases allocation, so it's not possible to refer a case to a judge with a specialization, so it's just random. But one last myth, probably not expressly touched upon. So if ICC is too international, so whether it's available only to international cases. So probably I will refer to Sergei first. And if we have two Ukrainian or more Ukrainian parties, if it's possible to refer the dispute to ICC.
Thanks, Elena. On the side of the ICC, there are no problem. We will accept any case. There are no limitations in terms of party's nationality. Then, of course, each party should assess, the applicable lex arbitri. If there are restrictions as to nationality, like for Ukraine, it would be law on international arbitration of Ukraine. So it will. What I can tell you is that the institution would not prevent parties from filing their requests and would allow the case to proceed. It's just every party should assess its own risks as to complying with the applicable law. It should be done at the time of drafting of the contract, not at the time of filing of the request.
Yeah, but as Vladimir mentioned a bit earlier, so in Ukraine there are no issues with that. So indeed, Ukrainian law on international arbitration and recent court practice and judgments of the Supreme Court are quite supportive also to that. Okay, I would like to move to one important also side, but important topic. So I think some of our audience might decide or think that the discussion of dispute resolution options is a bit premature in a situation when we are just like attracting investors or sponsors to Ukraine to launch different rebuilding projects. And let's discuss why it is not so, why it is important to discuss this now already. So Vladimir, would you like to start why it is important for the investors and sponsors to have, for instance, ICC arbitration in large construction projects, and why it is important to think of it, from the outset?
I'm actually came to after my experience in disputes in construction. So I will have been so excited by all these projects and in going to arbitration and so on. But more, of course, when it's go to arbitration, that I have also some experience in non-contentious like construction projects, PPP projects, so large infrastructure projects. And I would say that when we speak about based also of this experience, not only in dispute resolution, the main challenges for Ukraine for rebuilding, I see capacity of the I would say of people, resources to manage those projects. In particular, from Ukrainian side, because contractors, sponsors, bankers who will come. They experience, they have done it in other regions. They will do it in Ukraine, but they will speak with Ukrainian and usually team, yeah, especially its public side. They will meet Ukrainian law, Ukrainian regulations. Maybe they will meet Ukrainian courts, which they will wish to avoid, yeah, because they will, of course, want to come and wish to come now, and unfortunately, limited can be the now. But I think this is something everybody recognizes who is a party of in Ukraine, rebuilding Ukraine, and understand they understand that, and it's normal, it's alive. That the disputes, there may be disputes, yeah, at the end, and ultimately it's risk management that they would like, given if especially they're not experienced in Ukraine, to have a possibility at the end, given limited capacity of the Ukrainian side, limited experience, and their also limited experience in Ukraine, to be able to resolve their disputes, and they want to resolve them in a way that is fair and familiar. And usually, fair is what is familiar. Yeah, I already have experience. It was fair. It's me. I could win or not, but it was fair. Yeah, and so and they want to have fair resolution. So I think this is, and this is again why capacity, and what I mean about capacity. I wish that Ukrainian employers, yeah, especially public employers, because when it's private project, it's easier to prepare, to hire consultants, to involve lawyers, experience in arbitration. And we have Ukrainian arbitration practitioners who are very experienced, including construction project, including at ICC, and the various rules, on the foreign law, Ukrainian law. So we have all this capacity, like from private sector, also of consultants. But when it's rebuilding and public money and public employer, I'm really think that we need to educate and maybe somehow involved and to prepare the public sides that to strengthen their team, yeah, including to be ready to go to arbitration and to go international arbitration, because when it's international, you need to be international managed, you need to internationally represented, I would say, yeah, and in different level, yeah. Then maybe usually going to Ukrainian courts by the same team which has no experience, yeah, in this. So I think this is important, and it's also the same about experts. I try to find some experts in construction in Ukraine. There is no market almost, yeah. Those experts I found for Ukrainian construction, they were almost always their first case in arbitration. Yeah, so basically it's education for them. So they're experts, but not experienced. When you think about, I don't know how it's Romania, but when I went, for example, to Poland, they're already local experts, boutique firms which do construction experts, delay quantum services. There is no such market in Ukraine. So this is
not yet.
But yeah. But I think this is why we need to do it now, because when it will be, of course, this would come later, but framework needs to be prepared in advance. Yeah.
Sure. Luminita, would you like to add? Because I understand with the Romanian experience, this is pretty clear. I mean, not for rebuilding, but for ordinary construction projects. So why it is important to have ICC, and whether it is important to the banks, to European Union, to have not only FIDIC, but arbitration as well.
Absolutely. So historically speaking, as I was saying, the contracts concluded under the let's say arrangements before Romania joined EU and also after Romania joined EU, and which was based on the EU money. They were including they're providing for FIDIC contracts and including ICC arbitration. It's true that during the past 3 years there were a couple of pieces of legislation which changed the obligativity for the public authorities to conclude the typical FIDIC contracts to some sort of amended contracts, which are either excluding arbitration or are providing for a distinct arbitration institution. But this is, as I was saying, this is 20 years later, so that's a different stage and I think that more importantly, it was based on the know-how accumulated and on the development of the market during the past 20 years and the experience already acquired. And I would say that to Vladimir, I think that you will have the experts once you'll have the disputes. So that's something which follows the market. Once there is a market for experts, you will also develop the body of experts, and this is something which is a capacity. So I think it's a capacity building which is based on existing disputes. But what I would like to say is that at any moment in time, I would say also not necessarily from the financing point of view, because the things are being changed whenever there's a purely governmental investment. So it is up to the government to regulate how they want to spend the money and what type of contracts they want to use. So that's a completely distinct thing. What it is true is that from the perspective of the constructing companies, and it is also an important factor on what sort of companies you'd like to have participating to such important projects, such consequential projects, where you need to have highly reputable companies. You need to have fully bankable companies, so you don't need to get in the middle of the project with a bankrupt company, and therefore everything is being stalled, and the consequences are multiple. And from this point of view, the most reputable companies, they do insist, and they're looking to relying on dispute resolution systems which are offering, first of all, neutrality, an extremely important factor, and also predictability. And predictability from the perspective of also a contract which is easy to negotiate, a contract on which there is prior jurisprudence and understanding on how it functions, and of course what the risks are and how such risks are being transformed, or how liabilities are being assigned in the contract. And all those are extremely factors to be taken into account on using, and as a plus definitely for ICC arbitration as a dispute resolution forum.
Thank you very much. So we are approaching the end of our session. So any final comments or questions to each other before we conclude?
I can make a small comment if I may.
Yeah, please.
Just from my experience with capacity building exercises with Ukrainian authorities, they're very positive, to be honest. We were able to provide several seminars for judges on appellate level, where we had like a conference with many judges coming from different regions to Kiev for a full day seminar on arbitration. We've also touched on construction issues, and then also a separate seminar for Supreme Court judges who actually deal, like in both of them, Appellate Court of Kiev and also Supreme Court. Afterwards, the instances that will be dealing with enforcement, or any opposition to enforcement of awards. And I see that the judges are very open, to learn, although it's not always the case in other jurisdictions where judges would sometimes, perceive themselves as someone who should teach and not learn. Not in Ukraine. We also learned a lot as institution from this interaction. Same goes to various governmental authorities in Ukraine. They were also very much open, for seminars, for capacity building projects, etc. So I'm sure that in this regard, especially with actual practical, practice, and we have more and more cases in construction involving various stakeholders in Ukraine, it will only increase and it will only improve in terms of experience and in terms of understanding of the procedure when it comes to construction arbitration.
Thank you very much. If no other comments, first I would like to thank our panelists, and second I would like to overall conclude today's discussion of 2.5 hours. So I would like to we are really grateful to all the participants who watched us during this time and for the attention. We're grateful to all our speakers who found time in their busy schedules. In the end of the year, it's always hectic and like on the eve of the Christmas, and probably for many of you, it is the last event this year. So thank you very much. It was really insightful and informative, and I hope that would help Ukraine and Ukrainian parties to be more successful in their negotiation, in their project implementations on rebuilding in Ukraine. And thank you all for supporting Ukraine and for staying with us. With this, thank you very much and goodbye. And happy holidays to everyone.
Happy holidays. Thank you very much.
Thank you.
Thank you all. Bye.
Bye.